Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, on the heels of this video right here, we have been receiving thousands and thousands of comments, and we've been taking a look at them, and we are finding common threads, common questions that are popping up. And when we see certain questions pop up with some frequency, we figure, hey, that's a good topic. A lot of our viewers out there are interested in learning about that, and that gives us ideas for a video. This is no different. This idea actually came from many of you totally awesome viewers out there who asked this exact same question. And it is one that really warrants a good discussion when you take a look at the historical reasons for why pistol braces were even created to begin with. So today, let's spend a few important minutes and talk about what does the new pistol brace rule say about those with disabilities. Okay, so the issue we are talking about yet again today is ATF's new and improved rule on firearms with attached stabilizing braces. We just call it the pistol brace rule here, and it is essentially an attempt to take thousands and thousands of lawfully purchased, lawfully owned, lawfully possessed, lawfully used firearms and transition all of us into unlawful felons overnight, 120 days from now, unless we, of course, acquiesce to the government's wishes and register these firearms. Now, we won't get too political here, but we do need to talk about a huge issue, because let us not forget that the entire reason that pistol braces were originally designed was to assist those with disabilities to continue to shoot in this particular platform. It was those who perhaps had lost the use of one arm that they could still handle and manipulate and use these firearms appropriately despite their disabilities, okay? And that is the entire reason that the tactical pistol brace was originally designed, was for that exact reason, and that has always remained true about all pistol braces moving forward. Now, I recognize that some manufacturers got a little loose with it and continued to evolve their braces to do much more than just assist those with disabilities, but that is not every one of those manufacturers. And certainly, although I understand that many people have shouldered these firearms in the past, that again does not constitute all of you. And in fact, I know many individuals who do routinely use these pistol braces as designed to secure it to one arm for one-hand firing. The source of today's material will, of course, be the pistol brace rule, and specifically starting on page 90, that is where your Department of Justice talks about the numerous amount of comments received about what was perceived to be a violation of the ADA, the Americans with Disability Act, a huge piece of federal legislation passed in 1973, which basically says, hey, listen, regardless of disabilities, every American is entitled to enjoy the same rights and privileges, and we must accommodate them due to their disabilities. And it is an amazing piece of legislation, and one that I am firmly in favor of, okay? So, with that in mind, what is the ATF's response to this? Because in many ways, this coming from an attorney general who is of a political persuasion that apparently looks out for the disadvantaged, apparently looks out for the marginalized communities. No, in many ways, the way the Department of Justice responds to those who do qualify under the ADA is a big, gigantic FU. This is how the Department of Justice put it. Many commenters asserted that this rule violates the ADA or the Rehabilitation Act of 1973 and deprives thousands of gun owners who have disabilities from the joy of shooting their lawfully owned firearms. Specifically, commenters stated that ATF is prohibited from making such discriminatory rules under the ADA, and that Section 504 provides, in part, that no qualified individuals with a disability shall be excluded from, denied the benefits of, or be subjected to discrimination under any program or activity that is conducted by an executive agency. And of course, there were other commenters who expressed different types of concerns, including another commenter stated that ATF's rulemaking, for example, the purported activity conducted by an executive agency, discriminates against disabled persons by arbitrarily limiting design characteristics of braced pistols that enhances the effectiveness of the brace design for the disabled person. And there were numerous other comments found on pages 90 and 91, all relating to individuals with disabilities. Now, here's how the Department of Justice responds, and this is what I say when I think there's big, gigantic FU to anybody who qualifies under the ADA, because this is what DOJ says. The department disagrees with the commenters that the rule would violate the ADA. As an initial matter, the ADA applies to state and local governments. It does not apply to the executive branch of the federal government. Accordingly, because ATF is a federal agency that is not subject to the ADA, the commenter's assertion that this regulation would violate the ADA is incorrect. In addition, commenters' ADA objections to this rule are misplaced because the rule does not itself ban or regulate any particular devices. Instead, the rule articulates the department's best interpretation of the relevant statutory provisions, which are the source of any restrictions or regulations on certain firearms. So, the ADA doesn't even apply, so that's fine, right? Okay, now they did follow up and point out that no, the Rehabilitation Act of 1973, however, does apply. But again, it's a big old FU because this is how they responded there. In contrast to the ADA, the Rehabilitation Act of 1973 does apply to the federal government. However, this rule likewise does not violate that act. Section 504 of the Rehabilitation Act prohibits the discrimination solely by reason of disability in federally conducted programs and activities. The Rehabilitation Act requires that people who are disabled within the meaning of the act have meaningful access to the federal government's programs or activities. As applied here, the classification of firearm is not a program or activity as defined in the statute. Second, no one is legally entitled to violate the NFA. Third, as explained below, neither the statute nor the rule denies or impedes anybody meaningful access to anything. And this is how they justify that rather last, bold, and brash statement. This rule does not restrict the use of stabilizing brace. A weapon with a stabilizing brace may be possessed without any NFA restrictions if that weapon falls outside the NFA's determination of firearm. That is, the weapon is not designed, made, and intended to be fired from the shoulder. Thus, even after the issuance of this rule, persons with disabilities will be able to purchase and use certain stabilizing braces without regulation under the NFA. So as you can see, the ATF knows what stabilizing brace is best for you and your particular disabilities. You, the person who actually suffers from the disabilities, you simply do not know what you're talking about. So you need to be quiet and listen to what Merrick Garland has to say about it. The ATF and Department of Justice also continued with the response as follows. Finally, persons with disabilities are not denied benefits or subject to discrimination under this rule solely by reason of their disability. This rule articulates the department's best interpretation of the relevant statutory provisions, and ATF interprets and uniformly applies those provisions to every person. And that is wonderful. Always the equal opportunity individuals that they are. God bless the ATF. Now, here's what else they have to say. Notably, it appears that no commenter provided any specific information to suggest that this rule or the NFA's requirements would cause qualified individuals with disabilities solely by reason of their disability to be excluded from the participation in, subjected to discrimination under, or denied the benefits of any program or activity of ATF. Accordingly, there is nothing in this record to suggest that this rule would raise concerns under the Rehabilitation Act of 1973, and the department disagrees that this rule adversely impacts the disabled community or denies them the benefit of the product intended for them. And so for all of you out there who are dealing every day in your life with disabilities, understand that what the Department of Justice is saying is, first of all, many of the statutory protections that are afforded to you do not apply to us and do not apply to this situation. And even if it does, well, that's just too bad because you can still use some pistol braces in some situations. We haven't really banned anything. That, my friends, is how this administration and this Department of Justice views all of you who suffer from disabilities. Listen, you may have more questions about the pistol brace rule or anything else related to what's left of your Second Amendment rights, and you guys know the drill. If you do, you can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. In the meantime, let's remember now, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.